Yes, welcome to the No State Project here live from my fortified compound in Mesa, Arizona. Glad to be with you here today. Streaming on my YouTube channel, as well, of course, originating on LRN.FM, the Liberty Radio Network, LRN.FM, so you can get to stream both ways. My YouTube channel, of course, is No State Project, so definitely sub so that you know when we have additional shows. And I have an idea there's going to be more live broadcasts and not necessarily ones that I'll know well in advance. But if you're subbed, you're going to get notification there. But that's April 7th. I should circle that. It's April 7th, 2018, and glad everyone's tuning in today. Got a ton of stuff to get to. Not going to get to. I'm going to just right off the bat. We've got so much information on this particular show. We're not going to get to everybody, but we will be back live on Wednesday. So whoever I missed today, we'll get to. The number to call in, it's 218-632-9399, 218-632-9399. The passcode is 2020 with a pound sign. And you can also reach me on Skype. That would be Frank Rizzo 3. That's Frank Rizzo with the number 3. And so don't spell 3 out there, jerky. Just Frank Rizzo with the number 3. But please instant message me first. We've gone a few weeks now without any tech issues. So, yeah, let's not have anything like that spoil an otherwise good show. Instant message me first at Frank Rizzo 3. I am going to talk, Jan, I'm going to talk about risk management because this is coming up a bit more. I'm actually glad to see this, that the risk management stuff is coming up a lot more. It's coming more frequent, and I'm glad to see that. We actually have someone in Texas we're going to be filing in the court because his risk management claim for damages was denied. So, but we'll get to that. I officially now I have a self-admitted. It's kind of creepy. But somebody who is basically studying every word that I say and follows every video, and he's even making his own videos trying to debunk me. And I've mentioned his material on this broadcast far more than I should have. I did the last video I wanted to do was separate. It was when crazy jumps the shark, and now it's not like. I will set some ground rules here. I know I've even done videos, and I'll say on pretty much every show that dissent is always welcome. If you disagree with something I've said, call the show. And but that's not enough for some people. I'm actually being accused by someone who's supposed to be one of the most successful lawyers in American history, who has got a stellar record of getting hundreds of millions of dollars for his clients against government agencies, actually suing government agencies, and again, awards of over $100 million. This is, man, if you take him at his word, he is not only incredibly successful as a lawyer, he is incredibly successful at making money. He claims to live on a multi-million-dollar ranch, state-free, no state interference. And yeah, you gotta love the shirt, Maiden. Again, thanks to Don Blue Eyes for the tickets. Yeah, Maiden. If you get a chance, I think they're touring again. Definitely check out Maiden. So, where was I? Oh, I'm talking about Dissent. I shouldn't be just looking at at those things, but Maiden takes precedent. So yeah. So Dissent. So, all right. So, what he's accusing me of is that I'm actually censoring him. That even though he has a standing invitation to come on the broadcast, he's not going to do that, because what he wants to do is just put out videos, and he wants me to take his video and play the video. I have not seen the video. He thinks I have, and I'm quaking in my boots. I'm just so afraid. Like I've mentioned before, I may have been on a fool's errand, but I confronted Scott Bales, the Supreme Court Chief Justice in Arizona, a Harvard law grad, a guy whose education I can't even come near. And I confronted him on the issue of evidence. No, this is not going to be another witch show. But I confronted Scott Bales in front of not just 2 or 3 lawyers now. You're talking about a few hundred lawyers at the ASU Law Library, law students and otherwise. So I'm not afraid. I do a live broadcast. I have no way to screen calls. You can always ambush me. And the idea that just because I'm not playing somebody's audio, which could be upwards of a half hour, that does not mean that I'm censoring and not living up to my 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 claim of always inviting dissent. I do a radio show. I transmit it. I do the stream so that there's more ways people can hear the live stream. Not because someone can see me wearing an Iron Maiden shirt. No, that is pretty good. But that's not why I do the stream. The stream is so that's more widely available. That's where people actually hear the show. The majority of people hear the show after it's done, where it's not live. And here, I don't have to even edit the video because we're finally in HD. Not that that really is that big of a deal. So if you want to voice dissent, call the show. But doing a video and expecting me to play a half-hour video on the show before you will come on the show, no, I gotta tell you, that is a douche move. This is my show, and I have to have some kind of editorial control over that. And I'm not going to bore the living hell out of my audience by playing someone's half-hour video where I've already debunked this crap on other shows. I've done it on separate videos, and I've done it on the show. I've done it on the forum. How many times do you have to address this? So if anyone is, yeah, let's ambush this guy, not living up to his claim of accepting this. Yeah, I like that. I've even said, I will go on another broadcast. See, this is the thing. Oh, I have a mute button. See, if you don't shut the hell up and you don't answer the question, then I'll tend to use the mute button so that I can keep my show, my broadcast, to where everyone doesn't just turn it off. So if you're talking over me and you're doing a Gish Gallop and you're just not answering, or you're just not answering a question, I'm going to mute you. But I don't do it often. I don't usually have to. And I've already told this particular guy that I won't use the mute button. Everyone can go back and listen to the ICBM shows. I don't use the mute button because that was a hair up his butt too. Well, you had the mute button. You have to have some kind of decorum, though, when you're on the show. If you do a Gish Gallop, I'm going to mute you. It's the only way to shut some people up and to actually keep the flow of the show going. This is a show. There's a lot of important information, and I want people tuning in. I want them to be educated. I don't want them to be bored to tears by somebody ranting about me. And his video is on YouTube. I'm not censoring a damn thing. He's more than welcome, like anybody out there. 218-632-9399. The passcode is 2020. Give me a call. I can't. The only time that I can sort of screen calls is if you've called me before and from that number and I've programmed it in, and then I may not take the call, but that doesn't happen. So I said, give me your area code so I know it's you. And what I'll do, if you call during a Saturday broadcast, I will mute the feed. Not just, okay, I will mute the feed and not go to commercial. I've done it before where we've got so much content that we want to get to, and I don't want an interruption, and I don't want someone saying, you're censoring me, you went to commercial, and you didn't. These are all hard breaks, people. And if you don't understand what that means as a hard break, I have no choice. I can keep talking. The LRN feed is not going to feature me. The YouTube stream will. So I made an offer. I'll cut I'll cut the commercial. I won't do any commercials. I'll mute out completely. I'll even go on another broadcast, but I'll discuss that when I get back. My name is Mark Stevens. You're listening to No State Project. If you dissent, give me a call, and that's how we do it here on the big broadcast. You call and you confront me in person. You don't whine on email that I'm censoring you. The stupid things that we have. But we'll be back in just a moment. Don't go away. Yes, welcome back to the No State Project right here on LRN.FM and streaming live on my YouTube channel, No State Project. And the audio and video, well, the video, of course, I don't have to do anything for that to be available now, which is really cool. But you get that on my YouTube channel. And at markstevens.net, you can have the high quality audio, which is probably a bit better, a little bit better than we're going to get here on the stream. But appreciate everyone tuning in. Don't worry, we're going to get to the court stuff because that's some of the stuff that he wants to supposedly debunk me on and making these claims, crying about it on and I can't believe that an adult would actually try to maintain that when I have a live 4 hours of live broadcasting a week, that anyone can call and ambush me is going to turn around and make this ridiculous claim. Did you cry like this in court? Is that how you got the jury on your side? You got up there and you cried? They're censoring me. No one's censoring you. My gosh, man, act like an adult. If you think I'm wrong, come on, confront. This is the thing, everybody. I don't think he wants to confront me in real time where I can respond to his drivel right off the bat, and he has to back it up in real time. And then he can't go back and spend 3 hours working on a defense. I think it's the same thing with these lawyers when you get to court. And the prosecutor, even though every single thing that he's supposed to have everything in the file already, somehow needs 60 days to get discovery. No, it's because they're covering for them. And they say, look, we'll give you all this time to formulate a response. Do you need 60 days to turn around and give a 30-page response that uses the word frivolous 18,000 times? Because I'll give it to you. If you have the damn fact, and see, and this is something that he makes this claim that I'm not really asking questions, I'm just making arguments. And so the judges and lawyers are all absolutely on point that when you or I, when we go into court, that it's okay and justified and fair for them to not answer the questions, whether it's the prosecution, the judge, or the witness. It doesn't matter to this guy because we're not really asking questions. It's taking the form of a question, but we're really arguing. So years ago in Phoenix, Ernie's thing, the Freedom Summit, they did a video and it's online. And I'm saying, well, you make your accusation in the form of a question. And he's taken that to be the be-all, end-all. Well, let's examine something here for a second. When you or I or someone goes into court and you're on the defense, and let's say you have a defense lawyer, the defense thinks that this witness is actually the one who's guilty. This witness is not just the witness to the crime. They are the ones who perpetrated the crime. So they have an argument, right? Their argument and their position is this witness committed this crime. That's their argument. Well, how do they bring that out? They ask questions, right? Now, can you imagine the defense lawyer doing that? And someone like this lawyer as the plaintiff's attorney, jumping out of his chair, screaming, objection, that's not a question, it's an argument. I asked him for evidence proving his claim. That's an argument. So the idea that my asking questions because I'm trying to support an argument or disprove the prosecution's argument, all of a sudden, oh, Mark has an argument. Well, that settles it. You don't have to answer his questions. This is the type of crap that this guy wants me to play on from his video. The idea that I'm not really asking a question, that is nonsensical. That is ridiculous. And if you think I'm taking you out of context, 218-632-9399, passcode is 2020, confront me in real time. I don't want to hear any more of your crying on about me censoring you on YouTube. This is ridiculous to think that you are relieved or someone is relieved from answering a question, even on cross-examination, because I have an argument. That is just stupid. That is one of the dumbest things I've ever heard coming out of anyone's mouth, let alone a lawyer. And I've heard some of the dumbest things coming out of lawyers' mouths. This is the same one that when I ask for evidence to support a claim that's made, if I don't accept a non-responsive answer, I'm all of a sudden arguing philosophy. I did a whole video on this crap. I've already addressed this garbage that this guy is crying about. I've already done it. And I'm still happy to this day. If you want to pick up the phone, you want to man up, you want to just confront me right now live, let's do it. I will even, like I mentioned before, this is for anybody. If you're afraid of me having control here, set up another broadcast. Set up another live. It has to be live. And the reason why I say it absolutely has to be live is because I am not going to give you the opportunity to say that I'm editing your words, that you I'm so afraid that you absolutely crushed me, so I have to spend a couple of hours editing it before. No, it has to be live so that you can't accuse me of that. And so it's the same thing when we do things in court. You have to look at the stupid things you're going to say, and you have to do something preemptive to prevent that. They turn around, they say your argument's frivolous. Don't make an argument. Just ask a question. Even, and yes, so I gave this guy, since he's a multimillionaire, many times over. This guy is fabulously wealthy. He's got more money than anyone can spend in a lifetime, according to him. He could just very well take a few $100s out of his pocket, go and we'll do a broadcast live on another radio station. He can buy the airtime. I have no control over that live broadcast. None. He can gish gallop. He can talk over me. He can accuse me of all that other stuff. I don't have any control. But he didn't respond to that particular part. So I don't know how much more somebody needs to do to convince people. And I think it's just one person in particular. I don't think it's anybody who listens to the show. Anybody who's rational and is acting in good faith would say that, well, Mark Stevens doesn't really allow dissent. He's a lying piece of garbage that he'll stomp all over you. He'll go to commercial. He just uses the mute button. He's all over the place. No. And if I do go on certain things, like with Wit from Gilbert, it's because there's so much information that I allow them to say that I write things down and I want to address that. So the idea that you can come on my broadcast and you can gish gallop and you could go on and you can slip in your shots about me being dishonest and you can slip in these things about me being crazy. And you think that if I address that, then I'm all over the place? I'm a fungal. You got to go based on what the person is presenting. And I know most people think I give people like Wit way too much time. And granted, I want people to have their say. If someone disagrees, let them have their say. So this is just absolute nonsense to think that just because. So don't let any of this fool you. Don't let anyone talk you out of, well, if you have an argument, then your questions don't have to be answered because you have an argument. Come on. Can anyone really take such no wonder you will not come on this broadcast and support that crap in real time. I can't ask questions. They're not really questions because I have an argument. We'll be back in just a moment, so don't go away. Yes, welcome back to the No State Project. And I tell you, we don't have a lot of critics to the show, but this one just seems very persistent. And it just look. I don't mind dissent, and I do encourage it. And no, I don't censor anybody from coming on. But if you're going to dissent, at least get my position correct. Address that. I just. And it's just ridiculous. 218-632-9399, 218-632-9399 is the number. If you want to join the big show, the passcode is 2020. We're gonna have a surprise caller for the next segment. Glad that we're able to speak to him again. But I want to address more of these ridiculous points that, yeah, I've already addressed so much of this stuff. And I think this is another reason why someone like this won't address me in real time here on the broadcast, because when you ask someone like I did last time, I asked Whit from Gilbert if he was able to make a moral or ethical argument in favor of the organization like the Arizona state government or the United States government. He did not want to do that, not even saying yes or no whether he could. But and so I had mentioned that, because I think it's important before we start discussing these things and to know that when you're going into court to attack these people, not to attack these people, to attack their claims, to challenge their claim, is to understand the manner in which they're operating so that you can point out contradictions. We know that that the means is in direct contravention of the end, the stated end. So we can, so we use these contradictions against him to show it's unfair. So one of the things that was taken out of context, what we like to call cherry picking, like what happened during the Wednesday broadcast when somebody posted what was supposed to be a quote from the U.S. Supreme Court, where they were claiming that the Supreme Court was saying that a statute is not law, when the actual quote was an unconstitutional statute is not law. A statute is not law. So that is what happened here with this wealthy, fantastically successful lawyer, where I've mentioned and I've mentioned this a lot, and I do this in the heat of the moment, and so one or two words may get left out, but I think everyone who regularly listens to the show gets the context instead of trying to hone in on maybe one statement where I was talking really fast and missed a word. I don't know if that's really the case here, but it may be that I've mentioned that when we're going into court, we're not actually challenging the ticket. We're actually challenging the government and the legitimacy of the government itself. And he believes that is something that is done at the ballot box. That is so fantastically stupid. You don't get to vote on whether you have a government or not. You can't vote. I mean, it's just such and what I'm saying is that we're showing that the government and the entire process is unfair from the time the cops give you the ticket until the judge and jury may convict you or acquit you. You're showing that the system is unfair. You're not picking on one particular judge. So if you get a ticket and you're up there in Florida and you're challenging how unfair it is, it's not unfair because the guy with the robe on is just not doing what he was supposed to do. It's unfair because the system itself is unfair. That doesn't mean that we're not showing that the ticket has groundless and that there's no jurisdiction to prosecute you. Again, when you see these really stupid things, and criticisms about my work, it's understandable why he doesn't want to confront me in real time. And with Scott Bales, yes, I confronted him directly. And after he gave this ridiculous response that the evidence proving that the laws apply to me are other people that are prosecuted, when you point out that that's not a responsive answer, putting other people in prison does not prove that the laws apply to me. And if you don't get that with a Harvard degree, wow. Obviously, with his Harvard degree, he was just trying to make me look stupid in front of all the people that worship him. But any amount of critical analysis and even saying, well, in court, that's proper legal logic. You can go and use circular logic in court. Really? The laws don't apply to me because the laws don't apply? I can get away with that crap in court? Oh, come on. And if you're saying circular logic is okay in court, you're making the point for me that it is a rigged game and it is unfair from beginning to end. If you can walk in and legitimately argue in a circle, it's corrupt. The system is corrupt, not just because this particular judge woke up on the wrong side of the bed. So yes, we are challenging to get the ticket thrown out. We are challenging how unfair the system itself is. That if you go and you actually stick to the rules, that the burden of proof is on the prosecutor and that they have to have evidence, not just circular logic. The Rule 3.1 does not say that the prosecutor is permitted to argue without facts and law if he uses a circular argument. Really? Circular logic is something you can use in court. But my point is that's how unfair it is, and that is grossly unfair. And if that is an inherent part of the system, then what you're championing is a group of crooks. People who say that using circular logic and arguing in a circle, if you say that that is legitimate and legal, then you're championing a bunch of dishonest crooks. You're making the case for me that it is dishonest. So that's what we have to expect when we go into court. If they try something like that, you have to object. Well, Mark, there's not a formal objection for that. I don't care. You are in there in the fight of your life sometimes. And in saying the word objection stops things. And here's a thought. If it's unfair, that's a valid objection. If what they're doing is unfair and violates due process, object to it. Don't listen to some internet lawyer that will lead you astray otherwise. Well, they are allowed to argue in circles. Really? When's the last time you or I were permitted to argue in a circle? So what do you do in court when you got two idiots arguing in a circle? Who's right? Oh, that's right. You don't have an objective standard of proof. And if you don't have an objective standard of proof, you are running a scam. That's why I used to ask, do you maintain an objective standard of proof? They've never answered the question. What do you mean? Do you go based on the evidence or do you go based on circular logic and argument? This comes down to the same thing that I said, I don't know how many times. This guy and others like him want you to believe that it is fair for the prosecution to make legal claims and his witnesses to make legal claims against you without any evidence whatsoever, just circular logic, but you and I can't. He doesn't turn around and say it's okay for the defense to argue without evidence against the prosecution. That's perfectly okay. It's astounding to me. And to have someone who claims to be one of the most successful lawyers in the last 50 years, to be hanging on every word that I'm saying, to go through and combing through every video, and the best he could do is come up with this crap and then cry that I am censoring him, despite the fact that he is able to call into this broadcast whenever the hell he feels like. It's just, no. And so if you go and you listen to some of that, or you go back and you look at some of my videos where I quote him, you'll see that nothing he is saying it holds any merit whatsoever. And we already discussed in this case on this show about a motion that that was granted, but it turned out that the judge reversed it. And I have spoken about that on the show a number of times. It was not the judge is making excuses that he thought he was signing the prosecutors. So I have addressed that where anyway, we'll be back with a surprise guest in just a moment. So don't go away. Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network. Also streaming live on my YouTube channel, and this will be available on my YouTube channel immediately after the broadcast, of course, if you do miss the live stream or any of the live stream. And I will have the audio up today at marstevens.net. And it is, of course, still available on iTunes. So if you're subscribed on the iTunes, you'll get that automatically. So check that out. Also, remember, subscribe to the YouTube, as you will be informed when we do unannounced broadcasts. So I'm hoping that, and I'm willing to do that when I can, especially if you have dissent. And I mean, the dissent. And if you want to dissent, just call the show. It's not that difficult. I can show you where this guy must have spent hours this week going back and forth with email instead of just picking up the phone during a broadcast and confronting me live. So if you have real dissent, and confront me in real time. I would rather do it in real time because I think if you know what you're talking about and you're taking the time to call and you think I'm full of crap, then you should be prepared and you should be able to go toe to toe in real time. And not like with this Scott Bales, the coward who has someone run interference with him because somebody called him out on his BS. So that's the same thing. If you're going to come on the live, I'd feel bad for some. Look, let me get back into this, but he's been on the show before, so he doesn't have much time. Edgar, welcome back to the big show.
Hey, what's going on, guys?
I'm really glad to hear your voice again. It's been a while, and I'm glad that you're out. And so fill everybody in on what has been going on.
Okay. Up to this point, so I served 22 months in federal custody at a federal prison camp in Oakdale, Louisiana. I was sentenced to 27 months and 5 years supervised release for making a false statement on the federal side. And so now that I'm out, I can kind of talk to you guys a bit about some of the things that I didn't do. Just kind of a disclaimer, there's a lot that I didn't do that I learned from Mark that I should have done, but I didn't do them out of fear. Absolute horrible fear from the amount of coercion that is used by the federal system to convict people who are in general not guilty of violating any code. That being said, I learned that what Mark teaches you and what Mark talks about regularly on his shows and what he does in his activism is 100% accurate in how you are supposed to fight, and defend yourself against these people, because if we don't, it's much worse. And the fear that they put on you, saying if you fight us, it's going to be worse on you. The reality is that if you don't fight them, it's far worse. And in my scenario, I was morally swayed to kind of just let go, knowing that I've, through different motions since my conviction, have been attacking the conviction through writs of habeas corpus. On the federal side, it's a 2255, later followed by a 2241, and on appeal. My appeal's still pending, obviously, and but I've learned a lot more that I didn't know, and some of the things how we get on the groups and talk about that we didn't know about because probably we hadn't had an individual go through what I went through. Now that I've gone through it, I can come back and say, look, there is something else. There is an extra step these people are using to woo over the veil and cover your eyes and just subject you to their jurisdiction and haul your ass to prison.
What are they doing? And give us an example of most of us probably, and people are probably familiar how prosecutors turn on the heat. And that defense counsel will double team you, and they'll do the same thing, where they'll give you all the horror stories and put as much stress on you mentally to make a deal and to not fight this. So, what are some of the other things that you may have experienced that, as far as the fear that they were trying to instill in you?
And so, your own attorney, if you hire one, will tell you that there is an arraignment process at the beginning or at the inception of your charges, probably right before you even are or you're even indicted, or even even as you're indicted, you're presented with this indictment. You're read this indictment, and then you're asked to enter a not guilty plea. You cannot. They forbid you to enter anything other than that.
Okay. Well,
this arraignment is almost, I call it a phony arraignment, because if you can't plead guilty, it's not an arraignment.
So that's what I was going to ask you. So they conveyed to you that you had one plea and one plea only, and that was not guilty.
Correct. And the attorney and the prosecutor, the judge, you're all on the same page about, we're just going to read you the indictment. Have you been read the indictment? Yes or no is a question they ask you. If you answer yes, they proceed to asking you, how do you plead? If you say no, then they tell the prosecutor, please read it to him word by word so that he knows what he's pleading to, or have your attorney read it to you so that you know what you're pleading not guilty to. But you cannot at any stage say, well, I intend to plead guilty, but first prove to me that your Constitution and code apply. They don't even entertain the not guilty. And so it's a phony arraignment just to get you to say not guilty so that they can hand you a piece of paper that says, here's the scheduling order, here's your trial date.
But were you afraid to do so, or did you have the, I mean, because I know that they've said things to me, and I haven't been under the federal gun, and I'll admit, yes, the feds are worse than the state by a wide margin. I'll give you that. But I've still said things. So.
Well, I did. And so at this stage of the game, mind you, I had already been detained and denied bail. I had gone through a probable cause hearing and a bail hearing at the very same day. And I had been in the detention center in Conroe, Texas for about 15 days. After that, I go to this arraignment where this attorney my family had hired says, listen, we're going to talk to this prosecutor. The prosecutor's really, quote unquote, not a bad guy. He wants to work with you. He's gonna move away from all these trumped up charges, and we're gonna just say you made a false statement and be done with it. But for now, you're just gonna say not guilty, and we'll get back to it. That's really what my attorney tells me. Literally, I tell him I'd like to ask some questions, and he goes, "Well, you don't say anything. We don't want you to say anything." Well, I said, "Well, where's the indictment? I haven't seen the indictment." I tell him, and he tells me, "Well, don't worry about it. We'll get to see it later. Just right now, when you go up there, just enter not guilty. We'll deal with that later." And I said, "Well." I told him I'm not going to do that. And so he kind of takes a step back and says, well, if you're not going to do that, then what are we doing here? I said, well, this is an arraignment. I like some things clarified. And he says, well, I give him a script, basically. I say, hey, I need you to ask these questions. And he says, we don't have time for that today. This is literally, it's only going to take 2 minutes.
It only takes 2 minutes to be able to ask the question, have the prosecutor answer and present his evidence, and then you can plead guilty and be on your way. Or the prosecution doesn't present the evidence, and the judge does the right thing for once and throws it out because the prosecution hasn't met their burden of proof.
So I'm going to tell you what happened with me. I get up there, and the attorney that was representing me at the time says, okay, she's going to ask you a question, whether you read the indictment, yes or no. All you got to say is yes, and then we'll proceed from that point on. I wasn't going to do that, and therefore I didn't. So when the judge asks me, Mr. Avila, have you read the indictment? I say no, because I hadn't. I couldn't lie at that stage. I was already being charged with lying, so I might as well just tell the truth. And I said no. The judge takes a step back, looks at the attorney representing me, looks at the U.S. attorney and says, this cannot proceed. Says it just like that. Before the U.S. attorney could say anything, before I could ask the next question, my attorney goes, we'll waive it. He'll enter a not guilty plea within seconds of that. The judge slams the gavel and I get handed a piece of paper no less than 20 seconds later. I was mute. They muted me right on the spot.
Another thing that they like to waive is speedy trial rights. And I've actually watched lawyers do this where the judge was stunned. The prosecution was not able to get the results for let's say the sobriety, whatever the drug test. And defense counsel waives. Oh, yeah, we'll give him more time. Well, what kills me is how much money these lawyers make to just throw in the towel like that.
Mm-hmm. And it's an insurmountable amount of money. The federal side any case on the federal side, a lawyer will tell you they're going to easily charge you $25,000.
Oh yeah, no doubt.
At least.
No doubt. Hey, you know what? We're up against. I'm going to blow through the. So if we can have a few more minutes, because I know you got. I know you have to go. So, so those listening live, all right. Well, on YouTube stream, you're going to get there. Okay, so let's. Okay, so what's the next thing?
And we can do a full segment on anything else. I mean, I've got so much more. Much more.
Right. We'll have you on a Wednesday broadcast, or maybe a separate broadcast just for you, because we have so much material. But in the few minutes that you have left, because I know you have to go, what happened? I mean, did he at least file a motion to quash the indictment?
No, he did nothing. He was removed. I removed him, and I basically took over from that point.
Okay.
So I fast forward to the guilty plea. We make this plea agreement that I'm only going to be charged with making a false statement. It's going to be 6 months. I had already served 3 months. 3 months, I'm out. When I go to the sentencing hearing, the judge turns into Satan, and he says, "Mr. Avila, you, sir, are far more dangerous with a pen than Bonnie and Clyde were with a sub Thompson. I'm giving you 24 months above guideline. Boom, 27 months, 5 years supervised release. Good luck."
Did he? Did you have any opportunity to ask him? Do you have a shred of evidence to show I'm more dangerous than people with a Tommy gun?
I did not. But then I did file that. I did file a motion to disqualify based on that transcript, and I'll gladly share that motion to disqualify with everyone so they can see the different canon rules that judge violates by getting personal with me.
Yeah, I'm like, hey, I believe you, baby, but my Tommy gun don't. It's just, are you seriously comparing me to somebody with a Tommy gun? I'm not Jamie Dimon, you idiot. I'm not Lloyd Blankfein. I'm not Tim Geithner.
Right.
What the hell is wrong with you?
Right, and to top it all off, at the very end, he looks at his secretary and says, "Which case was this again?"
Oh.
Wow. Well, I wanted to say, well, hopefully it's the right case, because you just, literally belittled me in front of an entire family sitting right, in the church pews behind me.
I'm sure my critic down there on his multi-million-dollar ranch will somehow blame you for that. Or no, actually, he'll blame me. You never should have hooked up with this lunatic Mark Stevens. He made you more dangerous with a pen than Bonnie and Clyde with Tommy guns. Hey, look, I know you got to go. I just looked at the time. So,
well, you know what? I do have to run, but just to say this, if I went in sharp as a sword, I came out as a double-edged sword, and now they're gonna hear, and everybody's gonna hear from what I have to say, and people will learn. And there is a way. The feds aren't invincible, and what I've learned and what they've showed me is that they're completely. We can definitely defeat these individuals in that section, because they're throwing out something that isn't what they call an arraignment, and they're literally trampling over the presumption of innocence altogether.
They're literally tramping over the. Never mind. Somebody might get that reference, but I know you were supposed to follow me, but I guess you did. Yeah. All right. Well, look, we'll get scheduled off air. You let me know when you're available. If you can't do Wednesday, we'll do what we can to set up another broadcast during the week, definitely, so we can hear what you got to say. I'm glad you're out, though, and
glad to be out.
And one of the worst offenses they do is the presumption of correctness. That they tear that. It's not even an issue with these people. They don't even give it lip service. So, but hey, I do appreciate you coming on, and let me know when we can have you back.
Sounds good, Mark. Good to hear you, and hi to everybody.
Yeah, and we'll hear more from Edgar during the week. And again, I am going to take a little bit of a break. It's a top of the hour break here on the YouTube stream and LRN.FM, although you don't have to hear that. But I will be back in just a few moments, so don't go away. Yes, welcome back to the No State Project, live from the fortified compound in Mesa, Arizona. Second of 3 hours of Anarchy Radio right here from the fortified compound. It's April 7th, 2018. Glad to be with you live. We'll be live, of course, for the Wednesday commercial-free broadcast. And again, dissent is welcome, but we want to limit it to what's said on the show. And so it has to do with court, so, you know. And I'm still, if somebody wants to call the show and make a moral claim for government, I'd love to hear it. So that's what I was mentioning before about this critic. If you're going to show that the court system is fair, or you have to first make a moral or ethical argument in favor, showing that it is a valid organization, not just a criminal organization. And there's some pretty heavy-duty evidence to overcome. And I don't want to hear, well, that's what they accept in court. We're not sitting in court. We're not doing it by, that's like what Spooner wrote. Any band of criminals can make their robberies legal. They can just wordsmith it. So, of course, you got someone with an inherent bias, an inherent prejudice against the truth. Someone's not going to turn around and try and make claim and actually, answer questions about the ethical basis of or the morality of their organization when they know that it's criminal. Well, the courts don't say so. Yeah, they're crooks. They're freaking crooks because they force strangers to give them money. And if you think that forcing strangers to give you money is not immoral and unethical, call the show and make an argument, because I'd love to hear it. But to then continually to pound your chest that the courts are valid, and while ignoring the foundation like that, no, it's not. It's not. Doesn't matter what a judge says. Judges don't change reality that way. Just putting a robe on and making proclamations, like I wrote in Adventures in Legal Government Indicted. Just because you declare something doesn't make it so. That's why I love that scene from The Office when Michael declares bankruptcy. All he does is say, "I declare bankruptcy." And Oscar, it doesn't mean anything. And it's the same thing with the courts that some of these critics seem to revere. They are acting on behalf of and working for a criminal organization. That doesn't mean that they're committing, acts of violence. Not all crimes and all immoral acts are inherently violent. Fraud is not necessarily violent, but it's still criminal. It's still immoral. Hey, so let's get back to the call. Oh, I actually screwed up. And so I'm going to apologize to everybody on the caller line. I didn't actually connect, and I don't want to do that during a live broadcast. We're almost at the end of the segment anyway. So one of the things, a big thing this particular critic has is he keeps insisting that the application of the law, or the argument or the opinion that the laws apply, is philosophical and not something that you can take into the legal arena. Now, I think he's just limiting it to court. I don't. And I think he's even made a comment that the laws are not applicable until you're convicted. And I may have that wrong because I can't it's on the other computer. But this idea that I've mentioned and I address with him, ad nauseum. I guess it bears repeating because we have new people listening to the show, and I don't want them being, falsely led. Remember, it's not just the court's jurisdiction we're talking about. So when you get a traffic ticket, the question of jurisdiction is twofold. The agency that issued the ticket had to have jurisdiction to issue the ticket, as well as when they filed the complaint into the court, that the court now has to have subject matter jurisdiction. They have to have personam jurisdiction, territorial jurisdiction. And so let's just separate those two for a moment. They're based on exactly the same claim. The police officer is making a claim. And I can't begin to, I can only speculate as to what the motivation is for someone to say that that legal conclusion that forms the foundation of the prosecution's case, the police officer's case. The entire thing hinges on whether that's accurate, and why somebody would say that that is not it's not up for challenge. Do not call me during a live broadcast. If you want to join the show, please instant message me first, and I'll bring you up. And I can't bring anybody up on a live on a segment right now. I have to connect. So please instant message me first if you want to be on the broadcast. So the police officer's making this claim that, hey, unless we can even use zoning, it doesn't matter. It's a code violation. Even if it's zoning, they're saying the property or you're physically in Arizona, our laws apply. We have jurisdiction to write you these tickets. That is a legal conclusion, a legal determination. It is not a matter of philosophy. And I swear, I'm not a violent guy, but I swear it makes me want to choke a bitch out when someone just keeps going on and on and on and on about the same stupid thing. When somebody is applying the law to you and maybe like a probable cause determination, it is not a matter of philosophy. It is a legal determination that has to be based on evidence, and it sets the relevance for everything else. And to say that when you ask for evidence, for proof of that claim, and that if they have personal firsthand knowledge, and that if they give you an opinion and not actual evidence, they give you a non-responsive answer, that if you object to that and then don't accept the non-responsive answer, then suddenly I'm arguing philosophy. That is there, or go to the ballot. But that doesn't make any sense. If you make a claim, it doesn't matter what kind of claim it is. If you make a claim and someone asks you for evidence, and all you could do is make the claim again, repeat your claim, or give further opinion, that's not answering the question, and it doesn't relieve you of your burden of proof. What does relieve you of your burden of proof, and this is something that this critic just doesn't get through his head, is his successful, rich head. Just because you are willing to hurt me and put me in prison, or you put other people in prison, doesn't mean that you're excused from your burden of proof and that you're any less of a damn crook for trying to put something like that over. I mean, seriously. You know, sometimes you got to choke a bitch out. These damn judges, these prosecutors, that's the only language, and these cops, that's the only language some of these people seem to understand. And no, I'm not saying go out and do that. What I'm saying is they're bullies. And then they've got these people who proclaim to be rich and to be successful in court, who want to cry about censorship and try to discourage people from going in and actually defending themselves. If someone is making a claim against you, even in the legal realm, even in the government sphere, they have to be fair. They have to have evidence. Again, I've said this so many times. He doesn't email me and say, hey, the reason why they can argue without evidence and you can't is this. If arguing without evidence and making the foundation of your attack is immune from challenge, and you don't need any evidence at all, and you can actually just argue in a circle, why can't I? Why can't we do that? How come they don't accept that from us? How come they actually will accuse, threaten you with contempt for doing the same thing? If arguing without evidence was something that they were actually permitted to do, why is it considered an ethical violation? Why is it considered prosecutorial misconduct? Because bottom line, it's a sacred cow. This guy, if he is rich, if you really are who you say you are, you owe your success, you owe your money to a compulsory monopoly. People were forced to pay your artificially inflated price. You made your fortune off the blood of us. But I will get to the phone line in just a moment. So if you want to call, it is 218-632-9399. Passcode is 2020. So we'll be back in just a moment. Don't go away. And we're going to mute you. Welcome back to the No State Project here on the Liberty Radio Network. Also streaming on my YouTube channel, No State Project. So if you're not subbed, definitely get subbed because I will be doing other streams as they come up. So if someone is a critic and can't do the show on a Wednesday or a Saturday and they want to present their proof that I'm a scammer or that I'm just wrong, I'm an idiot, just some schmuck from Long Island. Although, no, that one I have to own. But if they want to say that I'm an idiot and I'm a scammer and whatnot, or my facts are wrong, my logic is way off, then I will set that up on another day. In fact, I'd go out of my way if this Juan Galt guy, if he's going to stop crying on my emails to me, and just come on the show and go toe to toe in real time. I've got nothing to be afraid of. I'm very confident in my position. I've researched it. I've got the evidence. I've confronted more than my fair share of bureaucrats from all over the world, attorney general, law professors, police officers, police chiefs. I've gone. So that goes for anybody. And so if there is a particular day you can't make it, I will do a live broadcast on another day just to accommodate a critic. So, but I do want to give this, I don't want to have any gish gallops. Okay. So if you're going to come on, it has to stay focused and no gish gallops. And if those who aren't familiar with that, that is someone like what Clint Richardson does. You literally go on for 5 to 8 minutes when you were given a yes or no question. So no gish gallops. That's why the only time when I use the mute button. So, but I'm going to unmute here. We haven't heard from him a bit. I hope he has some good news for me. We have Kerry from New Mexico. What do you got for us today?
Oh, just the same old, same old. I went to court here a few days back, and then I took in my little list of questions, and I asked them, and then finally, this judge has given me nothing but trouble. This is the one that sent me for a mental evaluation for asking a question. And this time she entertained my questions, and she answered pretty much everything except for the jurisdiction issue. And for whatever reason, I couldn't get her to dismiss the charges against me, whatever, and they set it up for another court case. Or I guess they set it up for another hearing or trial or whatever they do.
Well, weren't you going to be filing against them with a petition for a writ of prohibition, I believe?
Yes, I did. And I hadn't. Okay. What happened with that is I had to go the first time that I filed on one of the judges, then it wasn't filed in the right court, and then they dismissed it. And then she gave me time to go refile. And then I filed it the second time, of course, it was on a different judge. And we went in there because I had court 2 times last week, and that case also came up last week. And it cost me $130 to file. And when I got into the court, of course, the Attorney General's office was there, and they made their claim that they hadn't been served correctly. And of course, it just so happened that they appeared before the same judge, and the judge kind of took my side for the fact that there is no way that somebody in the last 5 years has filed anything against the judge, because nobody knows how to do it. Because when I went into the court, they sat there. It took them about 45 minutes for them to get my paperwork back to me. And of course, obviously, when we went into court, it hadn't been done correctly. So we're all the way back to where I need to go back in where I filed. And from my understanding is I needed to obtain a summons to serve to the judge, and then also serve the Attorney General as per rules of the New Mexico statutes. Kind of wild, but I mean, I can't imagine that nobody in New Mexico, and of course Albuquerque being the largest county for population, that anybody would have any kind of knowledge as how to do this.
It's fairly straightforward. I gave you the instructions, and so it's not necessarily, it's not a failure on your part, but so the judge did not accept their claim that they weren't served properly. So did the judge at least order a response to your?
No, she wasn't too happy that I've been there once and then it didn't work out. So then, as per her instructions, when I attempted it a second time, I still didn't get everything. I didn't dot all the I's and cross all the T's as far as the Attorney General is decided. So she made them elaborate a bit more. And of course, the Attorney General, there's myself, and then I'm up against 3 attorneys from the state. And
okay, but to me, I
even they couldn't open their books. They couldn't open their fancy law books and tell the court, to answer the question. So, as to how it would be properly done.
As to what do they need to find out is properly done? How the judge's lawyers are supposed to respond to your petition?
No, I can't just go in there and hand them the paperwork. It has to be given to them as per their instructions.
Okay.
Don't accept paper.
Well, Kerry, yeah, I gave you instructions. This is for you and everybody else. When we do a petition, something that actually has to be an original action that has to be served. Like on a judge, the summons, you have a summons and then you have the petition, the complaint. That has to be served by somebody at least 18 years old who's not connected to the case. So you have a process server that serves the judge. That's why the judge is the one that has to have service on him. You can't do that, but anyone else over 18 can. Service is not something that's very, complicated to do. Anybody over the age of 18 who's not a party can serve the defendant. And so you could have just hired a process server for like $30. And I went through that. They not only do they serve him, I said that they can file the complaint for you. They can get the summons for you, and then they can serve it. And then they do the certificate of service that they file with the court. And then it's just a matter of the court, addressing the motion to stop the trial court. And so you didn't have a process server actually serve them. So how did the okay, all right, we're up against a break, dang it. So let me mute you up. We'll be back here in just a moment, so just hold tight. I'm gonna see what I can do about getting some Dissent on the show. And yeah, Dissent is welcome, but when you've been on the show like a dozen times, it gets to be old. And all right, look, we'll be back with your calls in just a few moments. So don't go away. Welcome back to the No State Project. I love these YouTube comments. I'm trash. I'm lame and I'm trash. Okay. Welcome back to the No State Project. I got a lot of callers to still get to, and we're going to be getting a bunch of people on Skype. So we are only halfway through with the show, so we should be able to get to everybody. But let's get back to Kerry. All right, Kerry. So so did the judge throw it out and say that, or just give you instructions to serve them properly?
No, after she let them speak, and I tell you, I went on for 20 minutes, and she was really on my side, but for the simple fact that it wasn't filed right, she went ahead and went with the state, and then she dismissed my claim so that it be refiled correctly, so that it could appear before her court correctly.
Okay, and what day did that happen?
That happened about let's see, two Fridays ago.
And have you served them properly though?
No, I had not. I tried to get on your show or listen to your show last week, and I was trying from my phone, but your show never came on. And then, like, up until about 10 minutes ago, your show, I was listening to it on your website, or somebody's running your website on the No Province State Project. And I was listening to it there, and then all of a sudden you mentioned something. And then all of a sudden now it started coming up on my phone. And then right about then is to when I started talking with you.
Okay. You got to, this is when you're doing something like that, you can Skype me or email me so that I can give you further instructions. That goes for everybody. You don't have to wait until the show. I do field, believe it or not, I don't spend my whole day responding to critics on email. I don't spend nearly as much time as critics will do. I don't, so I'm very brief that way. That's why I say, call the show. That's what we do on the show.
Right.
So
I certainly could have used the correspondence, no doubt.
Yeah, definitely. Don't let something like that happen. When things like this happen, everybody, okay, good or bad news, you keep me in the loop. And so you need help, because this is not a matter of that I make available templates and just no instructions, I do the show to help people through the process. So but it's not just a show. So you email me, you Skype me, and let me know, like, hey, the judge threw this out. What I have to get to serve. What do I need to do? So again, and for critics, I will address emails, but I'm not going to spend hours like you guys do. And I'm going to focus most of my energy on what I do, and that's helping people. So definitely get that. I would go Monday, have a process server take care of that. It's only going to be like $25, $30.
Right.
And they'll take care of it.
Can I ask you?
Yeah, go.
Do I, in fact, have to serve the Attorney General?
No, you have to serve the judge. In this situation, the judge is the defendant. You have to serve them. I would not play games and assume that I can get away with serving their lawyer. You serve the judge, and you're certain that service is correct. Because they can come out and they say, well, he served us. We're not the defendant. We only represent the defendant. You have to serve the judge. So in a petition for writ of prohibition, the judge is the defendant. They're the ones who have to get served.
Can I ask the next question?
Yeah, of course. This is your segment.
When the state's attorney, and like I said, every time that I've attempted this, I end up with 3 attorneys over there, but I never end up with the judge. So what would I say when the judge doesn't show up?
When the judge doesn't show up? What, in the trial court?
Right. Yes. When we're having the hearing, whatever, and the judge doesn't show up, but obviously because the judge works for the state, then the state attorneys show up.
Well, no defendant necessarily in a civil context has to show up unless they're a witness. So that it all can be done by their lawyer. So the judge doesn't have to show up. But what's important is that the judge's lawyer does. And the judge's lawyer would have to present a valid argument and proof to convince the judge not to take jurisdiction over your complaint, over your petition. So it doesn't matter if the judge is there or not. As long as their lawyer is there, that's what's important.
I see.
Because the only time it would be important for the judge to be there is if in the appellate court with the petition, if that goes to pretrial and then you actually have a trial. Then, yeah, you can obviously subpoena the judge to appear and answer for the crap that he or she has been doing up to that point. But at this stage, no, the judge doesn't need to be there.
Just as they're determining whether or not I have jurisdiction with the judge. I see.
Yeah, they're gonna. Yeah, the court that you file the complaint in has to determine whether they have jurisdiction over the complaint.
Right, and that's been the issue both times, and both times that the case hadn't been. First time it was like they let it go to like a criminal thing, and then the second time we finally got it in a civil setting, but yet because of that the service hadn't been perfected to the judge and whatever, then they dismissed it. But they also dismissed it because one of their arguments is that the Attorney General had not been properly served. But from what you're stating is that I really only, in fact, have to serve the judge.
Yes, you have to do personal service on the judge. He or she is the defendant. The Attorney General is just their lawyers.
I would serve the judge at their office.
Just have a process server take care of it. Yeah, and they'll serve him. They'll serve him at his office, or they'll serve him on a bench.
Real fine, that'd be. Yeah, I need to move forward on that, and then like I said, the other thing of it is on my other case pending, is they finally came up with a deal that their case was worth $200, and of course that was due for the mailbox damage, and of course the guy actually used his mailbox from the next day. All he did is pick it up out of the dirt and put it back in a hole in the ground, and he used the same post, the same mailbox. And one of my questions too with the government would be if the mailbox is federal property, how did they get jurisdiction over it? But nevertheless, I can't seem to get past jurisdiction in that case. I certainly need to ask better questions than what I've been asking.
And don't drop the ball. If they do something like this where you have a petition and they say that it needs to be served properly, don't wait 2-3 weeks. Get it in there as soon as you can, because you need to get that stay of proceedings. The least you should walk away with when you file that petition is a stay of the trial court proceedings.
So they could hold it until I get it refiled properly then.
Well, you're going to have to get it refiled, and then they can address the issue. If you haven't served it, then they believe that's a jurisdiction issue. Yes, jurisdiction actually is important when you sue them. It doesn't mean anything when they're suing it, when they're coming after us. But yes, you have to get it filed again and get it properly served. But once it's filed, you can still ask for the motion to grant the motion to stay the proceedings at the trial court. Okay. We're going to get rid of some. I'm sorry. I got to moderate the chat. We got to get rid of someone. Yeah, we get it. Mark Stevens is boring. I get it. Okay. So as far as Yeoman, you could do the same thing in that other case. If the judge is rolling over and doing everything on behalf of the prosecution, you can file the motion to change the judge, and you could do the same thing there.
That's their procedure in these courts anyway.
Okay. Well, I got to. We're gonna have to finish this off air. You have to email me. So I got to let you go. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, and also streaming live on my YouTube channel. We'll be back with more calls in just a few moments. So the number is 218-632-9399. 218-632-9399. The passcode 2020 with the pound sign. Hell yeah, I nailed that one. So those who are listening live, I finally nailed a break. Yes, welcome back to the No Stay Project. Apparently, I backup account, man, somebody is really aggressive here today. So we're going to just, we'll edit that. Hey, it's YouTube. You're going to get comments like that. People, just trolling and whatnot, which is, it's not as bad as some YouTube. There's some, you could just go to an Iron Maiden video and people are fighting on that. That's the nature of YouTube. That's what they do. Let's see. We got Skype caller. All right. We have a Skype caller here, so you just have to kind of shout out what's your name and where you're calling from. What the hell was that? Your Skype caller. I think this is this Parker? Okay, we're going to mute them back up. Yeah, I think this is Parker. We have a Skype caller. What's your name? Where are you calling from?
Can you hear me, Mark?
I can.
Oh, okay. Yeah, this is Tom. I'm from Missouri again.
Oh, Tom from Missouri. Good news this time?
No, I'm slipping away slowly but surely. You're like a doctor that's handing out aspirin for everybody. They call in, they have a fever, and you tell them take an aspirin, and that's pretty much about it.
If somebody called me and said they had a fever, my prescription would be more cowbell. Oh,
yeah.
Okay.
But that's what it seems like. That's what it seems like we're going here, because we're just not making a dent into these people. I don't think we ever will, but we can keep trying.
Oh, come on, Tom. Oh.
Do you really? I mean, seriously? Do you think we're doing anything? They're still shooting people and killing them.
Yeah.
And it's pretty much the same news every day. I mean, how much of a dent are we making?
I don't know if we've made much of a dent, but I think we can continue on the course that we are.
I agree to continue for sure. Yeah.
I think that what we need to do, and I'm guilty of this too, we need to have more videos confronting them in public. And I am going to be doing a lot more of that as time allows. It's just when, you get drowned out. And
exactly. Yeah. There's too many of them. There's just way too many of them. They're being paid, and they're being paid with our tax dollars. And that really makes it rough on us because we're paying them to punish us.
Yeah, that's true.
So I have a quick question anyway, because I'm in a little bit of trouble and a little bit of a spot here. Probation's wanting to do an inspection on my house. Should I let them inspect my house, or should I tell them to go get a search warrant?
Well, I don't think they work that way with like search warrants. You can definitely question him as far as, look, I'm happy to allow you to come in if you've got some proof of jurisdiction here.
No, I'm not happy to let them come in.
No,
I'm absolutely not. To even come on my property, I have signs up that say no trespassing, but they ignore that.
Yeah, of course, because they don't consider what they're doing trespassing because they think they have jurisdiction. I'm just saying that it's just like when we have the unsigned plea of guilty. We want to get the conversation going and get them to know that you're acting in good faith. There's no way in the world they're going to be able to reduce the evidence, but you want to at least put the offer. Look, if you've got such evidence, then no problem. I can work with you, but I'm going to need to see some proof of jurisdiction first. It's better than just telling them, get the hell out of here. Put the burden on them.
No, I wouldn't do that. I wouldn't tell them to get the hell out. I would say, do you have a warrant for a search warrant? So what would they say if I said something like that? They'd tell me, okay, we'll go get one. And then they'd come back and they put cuffs on me and say, here's your search warrant. It's called an arrest warrant.
Well, they're not
right.
The thing I think what they would say to you if you said that in the local inspector needed a search warrant, they would say, well, we don't need a search warrant. We have a zoning regulation and we're allowed to do inspections.
No. This is not code or anybody coming to inspect. It's probation's coming to inspect.
Oh, I'm sorry. If it's probation, yeah. Man, you have to fight that in the court. If you do something like that, they're gonna violate you. They're just gonna arrest you.
Oh yeah, that's what I was getting at. So when they come here, I might as well just let them inspect it and don't even fight them on that.
Because if you fight it, you're going to go to jail.
Well, either way, you're going to go to jail if they don't like you. You know, if they come in and they find alcohol or drugs or guns or anything, they're going to say there's a violation, there's another violation, and you know they're going to find a violation if they want to find one.
Yeah, and have they? I mean, is this the first time they want to do an inspection?
Yeah, it sure is.
I don't think you have a choice here unless you file in court challenging.
That's what I figured. I hate that. It's like you're coming into my house, you're going to do an inspection. No, you're not. You're going to do a search. So if you're going to do a search, shouldn't they have to have a search warrant? What's the difference, a search or an inspection?
Because
they're both the same.
Because you are on probation, and I'm pretty certain as a condition.
And isn't that a joke too? Their probation. It's like,
sure.
Wait a minute now. Why am I on probation? You guys are forcing me on all this stuff. This is all done with force. It's not like you've got jurisdiction over anything now or ever had. So, but you're coming in here and you keep piling stuff up on me. Now you want to do an inspection on me? Go get a search warrant. What would they do? Do you think they'd arrest me right then and there? I mean, even though they don't have a cop with them, supposedly?
They would violate you right then and there. And if they didn't arrest you, they'd call someone to do it for them. So I think the only option here is you have to fight it in court. Part of the condition of the release is that they can search and inspect at any time. Being on probation is no picnic, and I wish I had more for you, but you'd have to file something in court. They will violate you. In fact, what sucks is you're so far behind the eight ball that just by filing against them in court might be enough for them to violate you.
Yeah.
So your hands are tied here. There's really nothing you can do. And this is a state violation?
Yes.
What you might be able to file a claim for damages against them with the risk management, which is what I wanted to have an opportunity to talk about. Jan, I did not forget that. But then again, has
anybody done that yet? Has anybody done risk management and come through with something on that?
Not yet. We do have someone in Texas that I'm working with right now that is going to file in court. People have filed claims and didn't pursue it after it was turned down. So the point is not necessarily to get any money from them. That would be great. The point is to be able to do something to get the prosecutor and judge off of their gilded thrones there and get them into a court hearing as witnesses and question them directly. When Mr. Prosecutor said that there was jurisdiction and I objected and asked for evidence and you denied that, what grounds did you? At least he has to answer that at that point. Now, is somebody actually going to get a judge and prosecutor under oath? We're trying in Texas. So someone I'm working with in Texas may be the first one to get that through. And I do want to talk more about that. But here I'm just it sucks because I know you said you were in a little trouble. I think you were being sarcastic there. You've had a lot. I'm not going to rehash all. You've had some serious. You're in trouble here, right. and there's nothing. They've got you. When you're on probation, you're done. Unless you want to take the risk of being violated arbitrarily by this piece of garbage, there's not much you can do. Even if you file a claim against risk management, that could trigger them to violate you. So.
Well, before I called you, I kind of figured that, inspection, they want to do an inspect. They call it an inspection. And I'm thinking that's not an inspection. That's more of a search or inspection. It's basically the same thing.
Yeah.
You can call it inspection if you want, but it's a search. So you want to come in my house, invade my privacy, which we don't have anymore anyways. So they want to do all that. So I figured, well, why don't I make them get a warrant for that? And I thought before I called you, he's going to say the same thing that I'm thinking. They're going to go get a cop and they're going to come back and say, we got our warrant for you for that inspection, and it's cuffs on your hands and you're going to jail. So I was right thinking about that.
That's all part of the probation process. So when you look at what's going on in the United States, it's not just the 2 million people that are in prison that are an abomination. it is all the family that's affected, and it's all the people that when they get out, they have to do probation, where probation sometimes forces people into having no choice but to commit more crime. I wish I had more to offer you, but we're at the top of the hour break. So keep me in touch. Let me know what happens. My name is Mark Stevens. You listen to the No State Project, of course, right here on LRN.FM, the Liberty Radio Network, and on my YouTube channel, streaming live from the fortified compound in Mesa, Arizona. We're going into the third of 3 hours of Anarchy Radio, so don't go away. We'll be right back. Now you can welcome back to the No State Project here on LRN.FM. 3 hours of anarchy radio right here every Saturday from 4 to 7 Eastern Standard Time on the Liberty Radio Network. And usually, at least every other week, on my YouTube stream. And I appreciate everyone tuning in there today doing that. I'm not going to give out the call-in number anymore because we're going to run out of time. We only got 4 segments left. I will try to go a little bit over today. We'll see. Got a lot of stuff to get to over there, so we will see. I will definitely be live on Wednesday. So if we don't get you on the big broadcast today, check that one out. So he's not been on the show before, but we've got Richard on the No State Project. Welcome to the big show.
I have been on the show, actually.
Oh.
I was on, I believe, a week ago, 2 weeks ago? 2 weeks ago, I think.
Oh.
And I was asking about, I was here for a vehicle code traffic issue. And I was getting some questions, feedback on post arraignment date. And just kind of give some feedback about that. So
where are you calling from? California?
California. Mm-hmm.
Okay, I see. Okay, well, what can I help you with today?
Well, I'm reporting back, and sorry I didn't let you know about this before, but it's been pretty busy for me. But yeah, I just wanted to get in here because I just had a motion hearing date, and I put in the various motions. I put in the motion to dismiss, request for judicial notice, and Brady discovery request and then I also added my own request to vacate plea because the commissioner who was sitting on bench or whatever, she entered in a plea in my name on the prosecutor's behalf, and just went ahead and did that. So I put in a motion for that as well.
Okay.
So pretty much what happened was it was another case of me. I really, fortunately, I wasn't quite as prepared as I tried to be. I've been doing role play and whatnot, but I wasn't prepared for what happened because when I showed up there, some of the points. One of the big points I wanted to bring up is that there was no plaintiff, accuser, prosecutor. The cop was not there. There was no prosecutor assigned. It was just me and the commissioner was responding directly to my motions and either giving the rulings on them or saying why she wasn't giving a ruling on some of them.
Well, you're at a motion hearing,
mm-hmm.
and the cop or no is it? Well, first of all, is a prosecutor actually assigned that you know of?
Not that I know of.
Okay, so the police officer should have been given notification of the hearing and should have been there because he's acting as the prosecutor. It's a minor traffic thing. I think, yeah, we're talking about a speeding ticket, correct?
Yes.
Yeah. Okay, so the plaintiff doesn't have to be there, but their attorney does. And so the cop is acting in that capacity. He wasn't there. So what did the judge do as far as well, let's start with the demur. What did they rule on the demur? Did they overrule it or did they sustain it?
They overruled it. They dismissed it, and really they responded to both. They responded to the issue of jurisdiction in when they got to the judicial notice, and they spouted off, the codes and case rulings, previous case rulings, that give the county jurisdiction, to give the court jurisdiction.
That's not what the motion for judicial notice was about. The motion for judicial notice had to do with certain legal principles that were brought up in the motion in the demur, and so the courts have clearly ruled that the courts can only, based on their own laws, can only hear justiciable cases or controversies between adversaries, true adversaries. So what response did they give as to whether or not it was an adversary system? Do you remember that? Did they address that directly?
No, they didn't. Unfortunately,
Of course.
I did bring up the issue. I didn't bring it up in the sense of asking, like, is this an adversary system? Unfortunately, but I did bring up, why is there no one here to respond directly to my motions? Like, why is the court, why are you responding directly to them? Why the person, whether it's a cop or whoever it may be, when I asked why is the cop not here, they said, well, the cop's just a witness.
Oh, did you ask if there was an assigned prosecutor?
No, unfortunately, no.
You see, and that's the thing. The police officer is not, unless there is a prosecutor. If there's a prosecutor, then he is not prosecuting it anymore. He is a witness at that point. But he still wrote the ticket, and he filed it into the court. He's just not actively prosecuting it at that point. So anyway, when they pull that crap and they say he's just a witness, you want to, well, objection. So there is a prosecutor assigned? And they'll say, well, no. Okay, so isn't he still, so who's prosecuting this ticket? It's the cop. That's one of the benefits of a place like New Hampshire. They're not going to pull that kind of crap because the cops do prosecute. They do act directly as prosecutors. So I'm curious as when they denied the demur, was there any explanation given?
No. Really, they just dismissed it.
Did you object and ask him if if their position was the prosecution did have sufficient facts?
No, because I wasn't sure who, they wouldn't respond. Like, I don't know, I guess in a way I didn't ask directly, but they never named that there was like a prosecutor of any kind. It was like, felt like I was being prosecuted by the judge, and I would basically, I objected. I think the one objection that I made when they were going over the points of jurisdiction and the codes proving it and all that, I asked what facts are there showing that the codes and laws apply to me because of geographical location, and and then she just rolled over it.
She rolled over it. Was it because
she remained non-responsive?
Non-responsive. Okay, there you go. So I understand. So I'm just going to explain again. If they don't we don't need to feel that confused that it's just you and the judge. We're still going to put it in terms of the prosecution, and because the judge is not supposed to be doing that. They're going to act on their behalf anyway, and we can object, and we can use that against them if we have to appeal. But here, just because the cop isn't there and it's just you, we're still going to focus on the fact that the prosecutor is the cop, okay, because he wrote the ticket. It's his ticket. So it's the same as if you were going to sue me and you wrote a ticket, you're the plaintiff. You wrote the ticket, but then you later go get an attorney and the attorney does it. It works the same way. Until you have an attorney, you're on the hook for the complaint that you filed. The burden is yours. So the cop is not relieved of his burden by just saying, he's just a witness, unless they put a damn prosecutor on there. And the cop as a witness still has the burden of proof because you put him on cross-examination, he has to support his claims.
Mm-hmm.
So, all right. So remember that if you have to go, well, you're going to have to go in there again. Was there any, okay, so did they grant any part of the motion for judicial notice, or did they just deny it?
They denied it.
See, that's the thing here. You really the motion or the demur is one thing. That easily shows that they are corrupt because they're going to not hold the prosecution to the burden of proof. They have no excuse for denying the motion for judicial notice. Right in there is the United States Supreme Court spelling out that it's an adversary system. So to deny it's an adversary system, what they're saying is that it's not a situation where the prosecution bears the burden of proof, and that it's more inquisitorial. Why would they? I have to mute you up. Well, why would they deny something like that? That's so basic. Because they don't have a true adversary. Because that requires the violation of a legal right and damage and evidence to support it, which they don't have. So they deny it. But we'll be back in just a few moments. Don't go away. Yes, welcome back to the No State Project right here on LRN.FM and streaming live, of course, on my YouTube channel at No State Project. And you can get the podcast at markstevens.net, and it's also on iTunes. So definitely check that out for getting the broadcast. So the audio will be up today. I want to get back to Richard in California. So we were talking about how the judges in California uniformly deny the motion for judicial notice. And that is proof of how dishonest these people are, that they're even denying that the system is adversarial. So in California, you can ask for judicial notice of court rulings. And so we put that in there as kind of a way to try to make it more difficult for them to just outright deny everything. Like, well, how can you turn around and deny this? So you could file a motion to change the judge. And yes, you can show that through her rulings, she is impossibly biased against you. And that proof is that she's denying that it is an adversarial proceeding. She's not just saying, well, these things are true, and here's your evidence to, the courts have ruled this way. This is the actual law, but it's not applicable here. She's just denying that that's true. She's denying that the courts have said that there has to be a corpus delicti. So you could file a motion to change the judge that it's impossible to get a fair trial from her because she's denying everything arbitrarily. There's absolutely no merit to her denials.
Okay. Yeah, I'm just trying to write these notes down. Something I have to look into, because I don't even know what to expect going into the only thing that's up next is the trial on the 27th, and at this point, I was hoping going into the motion hearing that it wasn't going to be the exact same commissioner who had railroaded me and through arraignment, and she didn't even want to let me ask my questions because when she denied my motion to vacate plea, she said it was because she only basically said I could only vacate it if I wanted to change my plea to guilty.
Okay.
And I brought up that well, you're still only giving me the choice of putting in another involuntary, unknowing, and uninformed plea. And she said that my clarifications were requiring her to give me legal advice. And I told her that they were simply yes or no questions, which, wasn't following the Socratic principle because she just outright said, no, that's, she just contradicted. She was just like, yeah, they do.
Wait. When they do that, but Richard, when they do that, when they pull that, you have to. I say objection. Are you on the impression I'm asking you for suggestions on how I should defend myself? She can only say honestly, no. Then why are you claiming falsely that I'm asking you for legal advice? I hate that, because when she says. This is for anyone, for everybody. When they say, yes, you can vacate the plea if you enter a plea of guilty, you say, well, yeah, I'm happy to plead guilty. Has the prosecution met their burden of proof on jurisdiction? Do they have sufficient evidence proving that just because I'm physically in California, your laws apply to me? That you move right into that. But I want to address your question with the little bit of time we have left for the segment and that what to expect when you get there on the 27th. Well, first, definitely do the role playing. And if we've got somebody in the area and you can post this on the Skype chat that they can go as a media rep, that would be great. What you can expect is that you should be objecting to the witness being put on the stand because there is no evidence whatsoever that he has personal firsthand knowledge of the matters he's testifying to, that the laws apply to you. It's 701 in California that the witness has that personal knowledge, okay? 701.
Okay, and another question, hopefully we can get to before the segment ends. It was a big concern to me. I brought up that the last proceedings, the previous court date was not being recorded, and that when I asked about this time, she said, no, they're not being recorded. It's infraction proceedings. They're not recorded. They simply have minutes of what is happening.
Well, you can ask if you can record it yourself.
Okay.
but as far as what I really want to get to, is that what the judge is going to do when you object to the witness being the cop being putting on the stand, they're going to completely ignore you and put him on the stand. They may actually say something, and somebody is connected to me and needs to mute up. Please, I don't know how that happens. How the hell does that happen? Anyway, they're going to put him on. The police officer is going to be put on the stand anyway, and he's going to give a narrative. You can object and say narrative, but there's no prosecutor, so they're going to allow it. So you need to make objections to his legal conclusions. Once he is done and you're going on cross-examination, you got to go right for this. You got to go right for the throat. You have to ask him, so you determined that I violated the law. You know, you've got the ticket to prove this. And then you can say, you determined on your own that the laws applied to me and that I violated them. Yeah. And you determine that the laws applied to me just because I'm here in California. Then you can go for the knockout. What evidence, if any, do you rely on to prove, sir, that just because I'm physically in California, your Constitution applies and that there's any jurisdiction over me at all? That is the game changer. That the judge is either going to freak out, not allow it, find you guilty on the spot, or they're going to do the right thing and they're going to allow the police officer to answer the question and he won't be able to answer. So you'll have to follow up. So when you determine that so you're not even qualified to determine the laws apply to me. So that you're not qualified to determine that I violated the law. So when you wrote the ticket, you did so with pure speculation, didn't you? And that's kind of, how you would follow that up. Most likely you're going to get into a headbutting contest with the judge, where the judge is not going to allow him to answer the question in a desperate attempt to make it still look like the cop has a case against you. And you need to be objecting to that. So when the typical thing the judge will say is that's outside the bounds of his testimony. You need to say, no, objection. Didn't he already just testify? Doesn't it go directly to prior testimony and his competency and credibility? And the judge is probably going to tell you, abafangul, and it's something you're going to have to appeal. So that's what you should expect. You should expect that is exactly how it's going to go with the direct examination and the cross-examination. And so getting into and doing the role play and maybe calling the show again, because there'll be another few shows and we can do some more role playing on that. I wish I had more time. I'd role play with you a little more here, but I can't.
Yeah, well, I'm definitely in the Skype chat, so do my best to role play with the guys. They're doing a lot to help me out, and ladies as well, and just really trying to get the best I can there. I just think that we try our best, but it's like as much as I role played, I wasn't prepared to just go in there and face the judge directly, and there's not even like a prosecutor, not even getting to face my accuser.
Right.
And
again, the judge is obviously slanted heavily in favor of the prosecution. And so you'll be able to bring that out pretty easily in the questions that you ask. And you're asking leading questions. Up against a break, so I got to let you go. My name is Mark Stevens. We're going to do our best to get to as many people as we can in these last two segments here on the big broadcast. So I'm not going to give the number out anymore. But if I do miss anybody, remember, we're live on Wednesday at Wednesday. So, the Wednesday stream is at 3. Hold on. So the Wednesday stream is at 3 p.m. Pacific Standard Time. So it's the same time it always is, but it changes for us in Arizona. So, but I will be back in just a few moments, so don't go anywhere. Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network, streaming live, of course, on my YouTube channel, No State Project, from the fortified compound. And every once in a while, somebody will ask me what the hell that means. And it goes back to years when they were prosecuting the Browns up in, I think, New Hampshire for not paying taxes, not paying the extortion money. And because they had seen through that, that and know that taxation is theft writ large, the media had to paint them as bad as they could. So instead of living in a house, they lived in a fortified compound, and that they had an underground, I think it was an underground dungeon to describe their basement. And that's what the media does. Because anytime you start making and showing, having evidence of just how dishonest the system itself is, the media doesn't want to hear that. They will only do the narrative of a few bad apples. But if you've got direct evidence and you have the proof that the system itself is criminal, oh no, we have to start killing the messenger. That's when they start trotting out the ad homs. That's why I say that. It's just been a part of the show for years. It disgusted me to a point, that they would describe a middle-aged couple's home as a fortified compound. What? Just because a gun is in there? Cops have guns. They take them home. Having a gun makes it, and that's the thing. It wasn't even a compound. So that's why I do that. So let me see if we get back. We only got a couple segments left. We're going to see what we can do to get everybody over here. I did have a Skype caller, but we've got hopefully an update from Carl. Coral. I'm sorry, I wasn't supposed to do that, but Carl from Fulton, welcome back.
Hey, Mark. How you doing?
I'm doing well. A little better now. You got good news for us?
Well, yes, no. I mean,
okay.
I got, when I was supposed to have the trial date, because the DA decided to give me more discovery literally the day before, they gave me a continuance. But I'm not so worried about the discovery as much as it gave me an opportunity to be able to write an appeal and an interlocutory appeal. And my big thing at this point is still preparing for them to railroad me into a trial, but writing the appeal. And at this point, I've done a lot of study on it, and I'm just not exactly sure 100% of what and how. It's just it's just a new area that I have not done yet. So that's my big concern. And if you have any advice on that, that would be great.
Well, are you having trouble writing the actual
petition? Not writing so much as just some basic. I know the formatting on the appeal is supposed to be a table of contents and all this other stuff, and I've looked at all of that. My big thing, I guess, is, and I've got some access, but I'm just not sure on a lot of case rulings to try and support what it is that I'm looking to say based on the due process violations that have been occurring.
Well, I do have some templates that can help out with that. Are you sure you have to do an actual appeal brief? I thought you were doing a petition for writ of certiorari. So that's going to...
Well, I've done that too.
And they granted review?
I haven't actually... They haven't contacted me yet. When I checked, they said that there wasn't any decision. But there's also been an issue too where they may be waiting for the transcript or the audio from the last hearing, which, as of yesterday, I was told that it's supposed to be a 10 to 15 day period, not a 7 to 10 day period like I was told originally. And yesterday was day 11 anyway.
Well, so have they stopped?
I'm still trying to get a hold of this audio to actually submit it with the petition for a writ.
Okay, have they stopped the lower court proceeding?
There's some things going on. Okay, I think they're scrubbing the audio right now, is my personal opinion, but I don't know for sure yet.
It's possible. Has the higher court stopped the lower court proceeding?
As far as I know, no, not yet. But I haven't actually.
Yeah,
and that's when I've requested a stay. So that's one of the things that I'm kind of wondering about, because nothing has happened yet.
Yeah, I would get into the higher court that's sitting on the petition for the interlocutory appeal. I would get a motion to stay the proceedings at the trial court. That the only thing that they can do is administrative stuff like getting you that transcript.
Right. Well, and that's basically where I'm at. Is I got the petition, the petition for the writ, in with the appellate division of the Superior Court, and the appeal is for the plea deal that I'd taken a few years back, the probation violation that they're trying to get me on. And then the interlocutory is on the current allegations. So, yeah, I've been running and trying to get an awful lot of stuff, a lot of ground covered. So,
yeah, that stay is very important.
My only real, what's that?
The stay is very important here. If you don't get that stay of proceedings, they're going to keep going forward and they're going to moot your interlocutory appeal.
Yeah. And that's the big thing, is on Monday, I'm going to be heading back down to the appellate division to find out specifically what's going on, why nothing has been done, and let them know specifically out of my mouth what's going on with the audio. In fact, before, on the way there, I'm going to stop by the courthouse again. They said that they would contact me. But again, they said between 10 to 15 days. It was 11 days as of Friday, yesterday. So at this point, I'm a little anxious to get things done, because, if they're holding the stay just because of the audio, I need that audio to get the stay from the appellate division enacted.
So you got some work to do on Monday. Let me know how that goes. So you could just let me know on an email or Skype, and just let me know, hey, I went down and this is what happened. So, and
just as a little follow-up to Ricky, because he's here in California as well, the Judge Andre, who's a complete tyrant, is definitely up there with Cheryl and Noble for sure. Absolutely. He actually did kind of acknowledge the judicial notice. He took notice of the Declaration of Independence and the Constitution and pretty much denied the rest. It's like, wait a minute, are you serious?
Wow. And this is a first.
Yeah. And it's like, It was like, so you're going to just split this chip right down the middle of the hair.
Wow.
So you're going to acknowledge some of it, not all of it?
But this is significant.
And it's like, yep, that's how it is.
Wow. I have never.
Yeah.
Like I said to Richard, it's usually a blanket aba fungul, and they deny the whole thing. Oh my gosh.
Yeah. This dude's a complete Looney Tune. He's a complete loony. And I found out the other day too that he's the supervising judge in the courthouse that I'm dealing with.
Yeah. So no wonder you're doing the interlocutory.
And he's the same one that was screaming at me for interrupting him when he interrupted me. He asked me a question. I started to answer, and he starts to talk and starts screaming at me for interrupting him.
Well,
and I've already filed a complaint with the Commission for Judicial Performance, and I've already heard back from them, and they already started their initial investigation to see if there's any reason to do a full-blown.
Well, hopefully they do. I'm out of time for the segment, but hey, I appreciate the update, and let us know Monday what happens.
Yeah.
All right, my name is Mark Stevens. You're listening to the No State Project here on LRN.FM and streaming live from the Fortified Compound on my YouTube channel. I will probably post this when I scan it, but the psychology board in Texas is taking my complaint seriously against Dr. William Barry Norman. So I'm just gonna go off air here for a moment. They had put in there, and I don't know if I even mentioned before, but yes, he just triggered the Carl just triggered that they didn't outright deny to do an investigation into Dr. William Barry Norman, the one who did the so-called psych evaluation on our friend Bao down there in Tarrant County, Texas. So they did. They did. The only thing is, I'm not going to, because they say that these are confidential, I'm not going to be able to get the details of any investigation. So I think it's what's important here is maybe having Bao's attorney find out what kind of information Judge Cheryl Hardy, what kind of information did she give him and Bao's attorney may be the only one to be able to get that, if not having to do some kind of public record request. What the hell did Judge Cheryl Hardy, what did she, because that's what I was told, that they have to inform the psychologist before they do the psych eval as to why they're doing it. So what did she put in there? Because she could have just flat out lied. She didn't have to say the truth. Judges and lawyers, we know lawyers. Good gosh, these people have a problem with the truth. I'm very curious to know because if she told him the truth, that this guy is asking questions, even if he asked the same question 10 times, it's not grounds to challenge somebody's mental competency. You're not crazy. And I want to know, what specific mental defect did she believe he had because he was asking questions? What was her diagnosis? What was her initial impression about Bao's mental fitness that she had to incarcerate him with no prior notice, and then he had to be locked down for 24 hours a day for 10 days straight with no medical attention? See, this is not just a matter of we're going to get you a psych eval and hold you here. We're going to deny you medical attention. And I know a psychologist is in a medical field, but he wasn't a psychiatrist. It's not like he has an MD and he's, okay. So I'll give you, that was, but it was like a 4 or 5 minute thing. And he was diagnosed officially with anxiety. So give me a break. You did this. So hopefully something is done. That at the very least he's censored. But I think this is something that goes much deeper than just Cheryl Hardy and Dr. Norman. He's a PhD. He's not an MD. He's not been in medical school, but he is a doctor. I want to know how deep that goes. Because if they do it that callously for Bao, I don't think that was her first time. That would be quite an escalation. That's like going from robbing houses to murder. That's an escalation that doesn't generally happen. So we'll see. I will post the document that I got from the psychology board there in Texas. We'll see what they get from their investigation. Because bottom line, nobody in their right mind could say that it is ethical to do a forced psych evaluation on someone who's not accused of being harmful to himself or others. And certainly asking questions is not grounds to challenge somebody's mental capacity. Gosh, I wonder what this woman said. What did she say? Oh, we've got one who can see. He's asking questions. And we all know that asking questions makes you more dangerous than a couple of criminals with Tommy guns. Oy vey. I tell you, these people. We are back here on the live stream, so welcome back. And for those who are listening to the live stream on LRN.FM, we have some extra material that will be on the podcast that you didn't get to hear. So what I was mentioning before the break was that the psychology board in Texas did take my complaint and accept it. So they could have turned it down on the basis that I wasn't the victim. But, the thing is, if you have evidence against a doctor, especially in a situation like that, why would you have to be the victim if you have evidence of wrongdoing? What a stupid way to limit how, if anybody who could write, a complaint, you got to be the victim. I have proof of unethical behavior. You're going to ignore it? These people. All right. I know this is going to upset a few people, but I'm going to do it. He's been on the show a bunch of times before. And I want to just heads up. It's going to, Whit from Gilbert, I will answer your questions. Please ask the questions without much narrative so that I can get to my ethical question for you. So you're back on the show, Whit. What are your questions? Whit.
Thanks for taking me on again, Mark.
Your audio is pretty bad.
Did you not? Thanks for taking me on again, Mark.
That's better. Okay. Yeah. Well, I'm glad to have you on.
Did you not spend the first half hour plus of your show talking about welcoming dissenting callers and not censoring them?
I did.
Yet I have heard no dissent. I've heard no dissent on your show today. And you're censoring what I haven't even said yet.
I'm not censoring you. I'm not censoring you. Okay.
You don't tell other people to get to their point and ask. You don't tell other people what questions to ask. Yet the one dissenting caller and the person that you've spoken to by name on air on this show has been waiting to talk to you. And then you come right out of the gate and tell me what I can and cannot say. And you get to choose the questions I ask you.
You see, you're doing it again.
That's not called having a conversation.
Wait, I have one segment.
Piggybacking on what you're.
Whit, I have to mute you up. I have one segment left. I need you to get to the questions because it's a time issue. If you keep going into a narrative about other things instead of just asking the questions, I can't address them. So I'm going to unmute you. I need you to just get to the questions, and please respect that it's a radio show and I have a hard break coming up. Okay, so please.
You don't hear me complaining about that, and I know it's your show. Don't ever tell me what to say when I call him to talk to you, especially when you've spoken of me by name at length. And then I've been on hold ever since then, and then you're telling me to get to my point. Forgive me, Mark. I respect you, but don't appeal to the mob, by the way. Who gives a rat's ass what some people think of me? If they want to take me on live, be my guest and have them put them on with me. But don't appeal to the mob.
I'm not.
That's disgusting.
I have a few minutes left.
Me as quickly as I can. Last time I called in, when I didn't call in about the role of government and its moral or immoral reason for being. I've already answered that question years ago to you when I first called in. Render under Caesar. Now, if you don't believe in the Holy Book, that's fine with me.
You're not getting to your question, though.
Answer for me as far as the moral and immoral role of government in this world that we live in, Mark. I don't. But to answer it in another way,
no, you have to just ask me your
men with guns.
Ask me your questions. I told you on Skype. Ask your questions. I will address them, and then I want you to address.
Do not tell me how to dialogue with you. You don't do it with anybody else. Don't do it with me, or don't take my call. I don't care one way or the other. But if you take my call, don't tell me what to say or do or answer your questions when you don't answer mine. You still have not. You said a bunch of lunacy about the Bush family. I should like to say that I believe in the death penalty for Betsy the cow, for mass murderers, and for preachers that lie. You're none of them. But you spoke about Bush. My old man almost died in Ardennes Forest in 1944. Mark, if somebody that's still alive today had anything to do with that, I should like them executed. I'm wondering why. I've alluded to it before. You don't take on real evils, you take on fake ones. Now, if the Bush family are responsible for mass murder in Panama, let alone in Germany and Europe, I should like to know why you're not doing anything about it.
I already addressed that.
Stupid speeding tickets and trying to help people how to get out of stupid speeding tickets, of which they probably deserved.
I already
Why aren't you doing anything about the Bush family?
I already addressed that on the show. There's nothing I can do other than you're interrupting me.
Is.
I did. When you're that rich and powerful.
You can fall around Mesa cops?
Oh,
they're rich and powerful. That's why you can't do nothing about it?
If you're
on the airs. Why don't they censor you now? How are you on the public airways if they're so rich and powerful? Mark Stevens.
Every time I go to answer, you keep interrupting me. So do you want me to run the clock and just give you the time, or do you allow me to respond?
Public airwaves?
How do I get on the public?
I'm not muted.
No, you're not, but you keep interrupting.
Answer the question then.
But you got to stop talking and allow me to answer the question. I'm not going to hit the mute button. I'm not going to hit the mute button for the rest of the show, but you're going to have to let me answer the question. I've already addressed this.
I'm not talking. I'm waiting.
You just interrupted me again.
Don't repeat yourself then. Go. Shoot.
All I can do is expose them for the deeds that they've done. I am not a prosecutor. I cannot bring charges. I am not even in a position to convince a prosecutor because they don't care. Okay. I've done many times and gave up a long time ago trying to get someone at that position held accountable. It's not because I'm just some little jerky wasting people's time with traffic tickets. It's none of us, you, me, or anyone else. None of us are going to be able to do it. I even spoke on the show about Bugliosi's book, who wrote a fantastic, basically an indictment against George Bush for war crimes. That's not going to happen. They're not going to prosecute him. That's because it's a criminal system, and they don't always.
I got your point. Can I respond to it?
Well, I didn't get to address why I'm still on the air, and people are taken off the air, and people are censored. Why am I still on? Because I don't have the social influence that would justify them going out of their way to take me off the air.
Okay, I'm going to respond to it as quickly as I can. You're on the public airwaves because you have a First Amendment right to broadcast in the public airwaves. And the evil Bush crime family, of which doesn't exist because they're not an evil Bush crime family, lets you on the public airwaves because they respect your right to freedom of speech and being on the public airwaves because they're not a monster crime family. But since you don't respect the government, of which you asked me a question to legitimize their existence, I'm going to say you're citing the government for not helping you out and taking care of these Bush crime families. By citing the government, what are you citing the government for? Who needs them? Go get your gun and go find them and use it, as I would if I believed my dad ended up in the Ardennes forest because of the Bush crime family. Notice you didn't mention Hitler or Nazis or any of the other bastards that actually committed the mass murder during those 6 years of war. You implicate the Bush family. To your shame, I don't believe you're a bad person. I believe you're stupid. You believe stupid things that are totally out of your mind. And I wish you well, Mark Stevens. And I hope that one of these days we can actually debate the Bush crime family on the No State Project, rather than me having to get pissed off at you for telling me what I should say or shouldn't say. But thanks for taking me on, Mark. I know it's about over with.
Well, not yet.
And you're not going to get capped tonight by the Bush crime family because they're not a crime
hold
family.
on. Now,
that's why you're in the public
can you make a ethical argument in favor of the organization of government? In general, the United States government or state government.
Secure these rights, life, liberty, and the pursuit of happiness, of which I think you find as self-evident too.
Can you answer?
Do need to be protected by men with guns.
You need to answer the question.
That's why we have a police force.
Yes or no?
I legitimize the government. I legitimize the existence of government to secure our rights.
But wait, that's not the question. You have to answer the question. Yes or no? Can you make a moral and legal or ethical argument for government? Yes or no?
Render under Caesar. That's what Jesus
is. That a yes?
Is it not sufficient for you?
Is that a yes or no?
You're asking me. Okay, let me put it.
You see, I answered your questions.
You're asking me a question you don't believe there's an answer to. If you want to play the $64,000 question, okay, do you believe in God? Prove it. I believe you
answer
do.
The question. I'm not asking you a metaphysical.
There isn't a God.
I'm not asking you a metaphysical question. Yes or no? Can you make a moral argument for government? Yes or no?
Yes.
Okay.
Yes. To secure those rights that are self-evident, life, liberty, and the pursuit of happiness. Now, the government that you and I both have to live under, I don't respect either.
I'm completely out of time for the live feed.
People that are banning the government as being mass murderers.
I have to mute you off for the live feed. Hold on. My name is Mark Stevens. We're done with the live feed here. So I'm going to see if I could take a few minutes after this to have Whit address what he said, how we can make an actual argument showing that the government is ethical. I don't think he can, but yeah, hey, we'll see. But till next time, salud. All right, so let me kill the feed here. All right, so we're going to go a little bit. We're going to go a little bit over. Now, what is your actual argument? I want evidence and propositions that are supported by proof and logic. what evidence do you have to support your claim that the institution or the organization we know as the federal government or the state government in Arizona, let's use the state government in Arizona, what evidence do you have to show that it is acting morally and ethically?
Okay, that's a general question of which there is no answer to. Specifically, government is ethical or unethical at times. I'm not here to defend the unethical administration.
I'm not asking you that.
Actors. That doesn't mean that government doesn't have a right to exist. The market is one answer, by the way, Mark. The market. You were born into a world that is a world of competitive interest since long before we were born. And you were born into a world that exists because of the markets and competing markets and evildoers and good doers and all of such. We're not born into the world that we wish we lived in. We're born in the world as it is. And if you want to affect change for the good, more power to you. Stick with your program. I'm glad to hear it.
But
I'm calling in to challenge you to think a second time, not to agree with me. You're asking me a question you know damn well there is no answer in your mind, so don't ask me it.
Hey,
just like I won't
calm
ask you
down.
God,
I'm being respectful.
One way or the other.
Calm down.
I am being respectful.
No, you're not.
You're driving me crazy. You're the one that appealed to the mob, not me.
I did. Look, you strawmanned my position, okay? I'm talking about the government as an institution, the way it's supposed to run. You started talking about few bad apples. I'm talking about the institution, the organization itself, how it's supposed to run and how it does run, not a few bad apples. Okay, so if you don't want to discuss that, you're interrupting again. Okay, I'm going to have to let you go. I did my best. I gave him a lot of time. It's just at a certain point, you have to drop it because I can't get a word in edgewise. There's video proof of it. I look, if you want dissent, which I'm all for, and yeah, I've been accused of that even on the show of not allowing it, which isn't true. But my gosh, he got too upset and interrupted me incessantly, and he's just too upset to have a rational discussion at this particular point. If he believes that he can make an argument, a rational, lucid argument on the morality and ethical part of the government, then do so. You have to show that how they operate and are supposed to operate is ethical. And that should be easy to do if you believe in that. But trying to say that protecting life, liberty, and property, or because I am actually able to speak on the air, I'm able to speak on the air. It's not because government. No, you have to address the actual look. If your argument is that the government itself is a moral organization, it's ethical, you have to show that the way they operate then is ethical and moral. And it's not. The fact is they are forcing men and women, they are forcing us to give them money. This is not an issue of God or whether you believe in religion or not. Religion is completely irrelevant to this. If you believe it's a moral agency, if you believe they're acting ethically, then you examine the way they work. How do they get their support? Is it voluntary or is it compulsory? If it's voluntary, man, you're well on your way to making a moral and ethical argument for the existence of government. If it's not, if it's compulsory, if it's forcing strangers to give you money and getting compliance through a prison system, that is not ethical. That is grossly immoral. And to try to invoke God and just say, render unto Caesar, wow, even if you want to go into the historical basis of Caesar, name one person who was Caesar who wasn't a maniacal, narcissistic psychopath with a history of killing his own family. I tried. I did. But you got to let me answer the questions. So the deal was I would answer his questions. Then he has to address my issue on the ethics of government, because you do not get to call on my show, and you shouldn't be able to call on any show and turn around and say that government is good, but a few bad apples, and then I'm not going to call you out on that. If you were insisting that government is good, you make a moral argument for that. Support your position. So I'll end the show here. Dissent is welcome. You just heard it, but now there's more proof. And I just sat back and I didn't have a chance. Almost every time I went to say something, he interrupted me. And I get my word, I didn't hit the mute button until right last when I had to drop him. So this is not any kind of evidence to show that I don't allow dissent. You just call the damn show. But don't expect that you get to dictate to me way things are going to go. I have hard breaks we have to do here. It is a radio broadcast, and there are hard breaks. I'm not even on LRN anymore. This is bonus material now. But you don't get to come on my broadcast. You don't talk to me and make claims about what I'm saying and not be able to back them up. I don't care about anyone's religious beliefs. I don't care. If you're making a claim, you bear the burden of proof. If you think that government is legitimate, call with your argument. Show where they are acting morally and ethically consistent with do no harm. If you can't do that, then maybe you should re-examine your beliefs. But getting pissed off at me, interrupting, and not allowing me to get an answer in edgewise and not allowing me to finish a sentence is not the way to go about doing it. Dissent, yeah, it is welcome. And nobody can say he hasn't had the opportunity to voice dissent because he's been on the show quite a few times. So, forewarned, you dang well better have some proof. Till next time, salute.